Jocelyn Stewart, also known as the Messy Military Lawyer on TikTok and Instagram, my website of www.ucmj-defender.com. Of all the military administrative processes that a person could be facing after they've come under investigation, maybe they've received a terrible evaluation, they've received a reprimand, now they're actually facing being fired from the military, kicked out prior to the term of service without benefits, is the Administrative Separation Board. For officers, we call this elimination boards, and sometimes you'll hear them referred to as a show cause board. An officer is having to show cause why it is that they should be retained in active service, which is slightly different from the Military Administration Separation Board, where it's incumbent upon the government to demonstrate why that person should not be retained. Whether you're an officer or where you're enlisted, having that really sound and learned representation at the board with you is of paramount importance. Every military member is entitled to a free or detailed military uniformed counsel to represent them at their board, if you are in fact entitled to a board. When you're facing elimination or you're facing administrative separation, you have a number of different rights. The very first step that you have to take is to be advised of which of those is your best option. Among them could be a resignation for the good of the service, a resignation in lieu of separation or in lieu of elimination. You also can put in what's known as a conditional offer, right? That you can say, hey, I have decided I don't want to stay in. I think my chances are really poor, but rather than giving me that other than honorable separation, I'm asking that you instead leave me with a general under honorable separation. You also have the right to submit written matters to try to persuade the convening authority of canceling that administrative separation action. And lastly, you certainly have the right to appear at the board to challenge the basis for separation or the basis for elimination and to put on evidence of your own as to why it is that they should determine that it's not founded by that preponderance of evidence standard. This differs greatly from what we see at a court-martial, where the government has to prove your guilt beyond a reasonable doubt. It's much easier for the military's representation, the government's recorder, as we call them, to be able to demonstrate factually that the misconduct occurred. The burden of proof on them at that administrative process is only proof to a preponderance of evidence standard, which is generally just more likely than not tipping the scales in favor of that it happened. It's so important to make sure that you understand and that you have counsel who understands all of the different permutations. We often hear uniformed counsels complain because they say the rules of evidence don't apply at the Administrative Separation Board. Well, as we like to say, what's good for the goose is good for the gander. If the military is not going to preclude the entrance of evidence based off of the rules of evidence against the government, they also can't do it for the defense. You are only limited in the way that you defend these administrative processes by the limitations of your own creativity and imagination. We often stretch those rules in order to gain the most advantage and to leverage the best potential outcome for that military member. We like to divide the different kinds of evidence that we put in based off of documentary evidence that undermines the basis. We also put on evidence of character. We put on evidence of witnesses and also of attestations in the forms of affidavits, sworn statements, and even just memoranda and letters of support. Those can come from fellow military members, people that you worked with before, people that you're working with currently, people in your civilian communities. Maybe it's part of your church organization. Maybe it's part of civic volunteerism that you do. We also demonstrate the breadth of your entirety of your service, because it's important that the board members understand that what they're characterizing is not only this supposed event that occurred or events that occurred, but they're looking at the totality of your service. How much has the military invested in training you? Are you an asset and a potential to be rehabilitated in their eyes so that you can still go on and do wonderful things for the military? If you are facing separation, this means that this can characterize and take away your benefits. This can take away your retirement. This can take away all the years that you've invested. It's so important to make sure that you have an advocate by your side who understands all the rules and how to leverage them for you. Make sure to like and subscribe. Messy military lawyer here, Jocelyn Stewart.